Welcome to Wealth Builders with your host, Anthony Congemi, brought to you by Crescent City Retirement Group, the show that's all about helping you grow, protect, and secure your financial future. From Social Security maximization and strategic 401k and IRA planning to tips on life insurance, Medicare, and annuities, Anthony and the team at Crescent City Retirement Group have the tools you need to help set you up for a successful retirement. It's time to take control of your financial future. Now here's your host, the trusted voice in retirement planning, Anthony Congemi.
All right, welcome to another show of Wealth Builders. I'm Anthony Congemi with Crescent City Retirement Group, and we believe we have a fabulous show for you today. I have my co-host with us, as we do every Sunday, Tony Shore. Tony, thank you so much for being with us this morning.
Well, it's great to be here with you, Anthony. I look forward to the show each week, doing the radio show with you and learning about finances, financial planning, retirement income planning, and retirement planning in general. And it's Wealth Builders. It's no longer Retirement Keys. We have a new show name and a new vision for the show, don't we?
We do. We do have a new vision for the show. So, as we've talked about many times, we believe there's really 5 key pillars to any sound retirement plan. Estate and legacy planning would be, top of the list. Obviously, investments, tax efficient income, health care, and taxes in general. So we believe there's 5 key pillars to any well thought out retirement plan. And so in our shows going forward, this month we talked a lot about estate and legacy planning and some of the mistakes that are that people will make. We are fortunate to have Chip LeCoco with us this morning. He is an estate planning attorney here in New Orleans, a Jesuit graduate, Loyola graduate here in the city, and been 30 years in estate planning. I believe Chip's dad was an estate planning attorney prior. So, Chip's certainly been around it. And, of course, in Louisiana and specifically, our laws are a little different. And so we're really, fortunate to have an estate planning attorney that is, born and raised here and very familiar with our laws to help our clients. So, we have a special guest with us this morning, Chip LeCoco. And Tony, again, I want to thank you so much for all the contributions you've made up to this point with our show. I mean, we couldn't do it without you, buddy.
I appreciate it. And wow, we've got a huge get for the show. I don't know how you did it, Anthony, but you got Chip on the show. Once again, he's a great guy. Tell us about Chip.
Well, as I say, Chip was a Jesuit graduate, went to Loyola, been practicing estate planning here in Louisiana for 30-plus years, and really has just been a great partner for us with our clients. As I mentioned, we believe and we know, actually, that estate planning and having all your ducks in a row is so important. I mean, over the years, we have clients that pass away, and if they don't have their estate planning in order, the documents are old, so we're really honored to have Chip with us. He, like I say, 30 years of estate planning here in New Orleans, and helps a lot of our clients with their estate planning documents.
Well, that sounds great. So, Chip, welcome to the show. It's great to have you on today.
Thanks. Very excited to be here. Love to help, get my knowledge out there for what I know about estate planning here in Louisiana.
So you've been doing this a long time, helping people with their estate planning.
Long time.
And Anthony, why are we talking about estate planning today? We're talking about this because you don't want to leave your loved ones in a bad situation, right?
Absolutely, Tony. We see time and time again with folks that don't have their documents in order. It really ends up being, somewhat of a mess. I mean, even in my own family, I had an aunt who didn't have things in order. This was many years ago, and it was just a mess in our own family. And then you can see people that really do take the time and make sure documents are in order and their wishes are in order and how smoothly things go. I mean, actually it's I feel like it's kind of like your final love letter to your family, to have things in order and have things well documented. So we have today, Tony, and I want to send this to our listeners for those that are interested, but we have the top 10 estate planning mistakes and how to avoid them. And so what we'd like to do is just kind of go through these, or go through as many as we can, and we can have Chip comment on them as we go.
Sounds good. So where do we want to start?
All right, so number one on top 10 estate planning mistakes and how to avoid them. So number one on the list is straight out not having an estate plan. So Chip, tell us what an estate plan is and why it's important.
Well, I think, this is going to kind of touch on a lot of the other planning mistakes that we get to during the course of this conversation. But not having an estate plan, what really matters, let's just think about our current snowstorm we just had here in New Orleans. The difference between a city that can prepare because they have the equipment to get their snow off the roads makes it a whole lot easier than here in New Orleans, where we really struggled to get back because we don't have the equipment, right? The same thing can be said about an estate plan. What you're trying to do with an estate plan is to create a situation where your assets are going to go to exactly who you want it to go to, how you want it to get there, and whom you're going to put in charge to make sure it gets there. The quick example I can give would be if you don't have an estate plan or you don't have a will in place, and let's take a very simple example. Husband and wife get married. Husband, let's say, brings a house into the marriage, though, so it's his house. They don't do a will. They live in the house for 10 years and they die. That house would be his separate property. Under the laws of intestacy of Louisiana, meaning he died without a will, that property would go to his children, not to the wife. You could cover that with a will, and that's the difference between having an estate plan and not. If they don't have children, for example, in that situation, his house would go to his siblings, who may not want the wife to continue to live in the house.
Right.
So the purpose of an estate plan is really to offer protection to both your spouse, your children, other loved ones, and to make sure that your estate goes where you want it to go.
Very good. Number two, not updating the estate plan, failing to review and update your plan after major life changes like a marriage, divorce, birth of a child. So what do you see there, Chip, as it relates to, people having some major life change?
A will it's an ever-evolving document. I tell my clients all the time, every year, once a year, review your will, find out, make sure you know where it is, and then just kind of go through it and just see, is there anything I need to change? If you got remarried, of course you want to redo your will to cover your new spouse. If you have another child, you want to make sure that you add your child in so that they would participate in the will. Or if you're going to do a trust for that child or for your children, and you had another child, then you want to go ahead and again make sure that child would be included as well. That's the importance of always updating your estate plan, making sure, if you're going to give specific items to people, if those items no longer exist, or you've gotten other items that you want to give to people, that those are all included in your will. So it's a good thing for every year to just update your estate plan. And if you have a life-changing event that occurs during within that year, let's say, update it then and there. Somebody dies, somebody's born, then you want to update it right then and there.
So always a real good idea to especially in these types of major life changes.
Correct.
Number three, choosing the wrong executor.
So the executor, let me explain that first. The executor is the person who you name in your will who will handle all your affairs upon your death. They will basically take control of the estate and make sure that everything's handled, all the bills are paid, the monies and assets are all gathered together and ultimately are distributed out to the legatees under your will. In an intestate succession, just to let you know, that executor is known as an administrator. But when there's a will, they're known as an executor, okay? In Louisiana, we have independent executors, which means in your will, you can appoint that person to act as an independent executor, which has streamlined the entire probate process, has made it a whole lot simpler and cheaper. What it means is an independent executor, once appointed, doesn't need to go run back and forth to court. What's important is that who you select as that executor, it has certain responsibilities and will have a lot of work to do relative to the succession. Most of the times, the first thing they're going to do is hire the attorney to handle the thing with them. So you'll see people who automatically, let's say, wife is already deceased, or husband's already deceased, so they'll choose one child, and usually they'll say, well, that's the oldest child, let me appoint that person. That may not be the best person for them to name. Either that person may be out of town, which you can still do it if you're out of town, but it may be a better option, or may not be savvy enough to handle it.
Right.
So you want to choose the person who you believe is most qualified, who will do it in a very professional and quick manner, and you not be antagonistic with other people in the succession. And the other key to remember is that the executor, a lot of people also try to do co-executors, meaning, I got 2 kids, I want both of my kids to be co-executors. It makes it difficult when you have co-executors because most banks are going to require or want one voice to be heard for the succession. So my recommendation is always to a client, if you can, try to choose one person and then name substitutes in case that person can't act. It's very important to have substitutes so that way you have a backup. But you always want to name one person as the executor.
Very good. All right, good. So picking the right executor, of course, is important, and then having those backups if that executor can't do it. Number 4, not planning for incapacity, failing to designate a durable power of attorney or healthcare proxy. What are we saying there, Chip?
So, and this is the sad part of my practice. That is when you get a phone call from a family member, mom had a stroke, mom is in a nursing home, we need to access her accounts because we need to pay her bills, and mom did not do a power of attorney during her life. And the power of attorney is basically where you're appointing an agent to act on your behalf, both medically and financially. You could do it just for medical, you do it just for financial, or you can bifurcate it and do it for both, right? So in that situation, mom can't act for herself. She hasn't appointed anybody. So then the family's only option is to go through an interdiction proceeding, which is where you're going to get a curator appointed. In other states, it's called guardianship. Here we call it interdiction, which is a very expensive process, a very public process, all involving a judge and a lawsuit and attorneys and determining whether or not the person's truly incapacitated. All of that could have been avoided with simply doing a power of attorney and appointing someone they trust in a position to handle both their financial and medical affairs. And again, the key to doing that power of attorney is always to name a substitute. So if that person can't act, then they have somebody else in their turn, and then somebody else after that.
Number 5 on our list of the top 10 estate planning mistakes to avoid. And again, for our listeners, we have this PDF that we want to email or send to you if you would like to have this conversation, this document in writing of the different points that we're discussing here on the show. As I mentioned in the beginning, estate and legacy planning is certainly one aspect of retirement planning, but it's a biggie. We think that there's really 5 key pillars to any sound retirement plan: investment strategy, income planning, healthcare planning, taxes, of course, and then obviously estate and legacy planning. But estate planning is really critical. It doesn't have to be expensive, but if the documents are not in order, as Chip's been discussing and alluding to, it can be very expensive if things are not clear in your estate plan. Number 5 on the list is not considering taxes. So what are we talking about here?
And this would be well, let's take this. I guess there's 2 types. One would be estate taxes, inheritance taxes upon death. In Louisiana repealed estate inheritance taxes many years ago, so there's no state inheritance tax to pay upon your death. Relative to federal inheritance taxes, for 2025, the exemption amount is about $13.7 million, which means your estate would have to be over $13.7 million before you ever got to a tax. For a married couple, that's almost $27 million for a married couple. It's supposed to sunset on December 31st of 2025, the law, and it's supposed to come back down to, I think, $7 million per couple. I'm not sure with the Republican Congress now and with Trump in office if they're going to change and go back to this figure, but we'll have to see how it plays out. But just keep in mind that it is being reduced, but it's coming back down to $7 million per couple. So Before that, when I got out of law school, for example, the exemption I think was $600,000. So estate tax planning was a very good big component of estate planning. At a $13 million exemption, it doesn't have much of a role for many clients. Some clients, of course, it does, but not many.
So all right, very good. So we're gonna move on. We've talked taxes. We've talked about not having an estate plan, not updating your estate plan, having the wrong executor, not planning for incapacity, durable power of attorney, and healthcare proxy, taxes. Number 6 on the list: forgetting about digital assets. So what are we talking about here?
What's that?
Like a will, my power of attorney is an ever-evolving document, right? But our power of attorney got started by my father, who got out of law school in 1963, went into this area of the law, and I say our power of attorney has been worked on ever since then. Every time a bank or somebody said it doesn't have that, it's been added in. The last thing I've added into that power of attorney is digital assets. And think about it in terms of Facebook, Apple IDs, anything regarding social media, or any sort of anything related to digital stuff, right? In our power of attorneys, you're giving that agent the authority to access and to get control over those items, those assets. Now, of course, even now we have digital assets. Think in terms now, and even expand it now, Bitcoin, assets that are digitally there. I'd say the most important thing is, number one, make sure it's included in your power of attorney, and number two, that somewhere where you keep your will, that you keep a list of all your passwords, so that if you pass away or if you become incapacitated, either your agent or your executor can get access to your accounts and to where your stuff is.
Yeah, so I guess people, years ago, digital assets or social media, or people having these types of accounts, or Bitcoin or cryptocurrency, none of that was around. So as you say, as time marches on, y'all have to continue to update your power of attorney to meet the needs of the day.
Correct.
Number 7, not providing clear instructions.
Yeah, this is the nemesis, right? This is where you do a will. I would say hopefully a lot of times you're not going to see this where it's a will that's been drafted with an estate planning attorney. Can't say it's always, but that's the hope. You see this a lot of times in a handwritten will. In Louisiana, we call those allographic wills. Must be dated and signed by the testator. By completely in their handwriting. What they're trying to describe, what they're trying to give away, just doesn't make sense. It doesn't come across exactly how they're trying to do it, and it just creates havoc. A lot of times what you'll see, too, is, and it's kind of a...
You're talking about inside the will.
Inside the will. The will itself doesn't really...
Isn't clear.
The other one you'll see is sometimes people draft the will, and they go to a lay notary who will notarize the will for them. Here, sometimes, again, it doesn't really get across exactly what it's trying to say because it wasn't drafted by an attorney. It was drafted by the decedent or the testator, who then got a lay notary to do it for them, or just to notarize a signature for them. Again, you got to be careful. You just want to make sure that it's done clearly, and it makes it easy to pass to exactly who your beneficiaries are under your will, so that there's no question where it goes, how it goes. I'll give you one example I had in one of my successions was where the person wrote a will and they gave away 120% of their estate instead of 100% when you added up all the different things. So it can be, that's a simple example of how clear understanding, clear instructions can be very confusing sometimes.
And then if you have somebody that tries to, if there's any contesting, or if there's other issues like that, that's when things can drag on.
That's when it can drag on, and that can drive up the cost, right? So if you do a will that provides exactly what you want it to do, it's done properly, there's no way to contest it, then it makes the whole process streamlined and a whole lot simpler.
Very good. Yeah, so number 8, so not coordinating beneficiaries. So with the accounts, retirement accounts, 401ks, IRAs, 403bs, annuities, life insurance, Chip, so these accounts have designated beneficiaries. So is it fair to say that when someone passes away, they have to do a succession, if you will, to transfer assets, but that would not include these beneficiary accounts, correct?
when you do estate planning, you always say you look at it from the succession probate side. You look at two buckets. You have the estate bucket and the retirement bucket. The retirement bucket is going to go to the beneficiaries. Has nothing to do with the will, has nothing to do with the estate. Upon the death, you're going to make the claim with the company, and they're going to pay out to the beneficiaries. That includes life insurance, 401ks, annuities, IRAs, any sort of qualified retirement account that you're talking about. Mm-hmm. That's who's going to get it. When we talk about coordinating beneficiaries, you want to make sure that who you want your beneficiary to be in those retirement accounts is making sure that's the right person that you want it to go to. The other way would be...
Because it would supersede the will, wouldn't it?
Supersedes the will.
Yeah.
And again, where I really would point out relative to coordinating beneficiaries, let's say I have 3 minor children. My wife and I do a will. We create a trust to leave everything to our children in trust to them, to the 3 children.
Mm-hmm.
And my wife and I pass away in a car crash together, right? So my 3 kids, all the money that goes to them, the house goes to them, everything's protected because it's going to go into trust. But then I have a life insurance policy that I list them as a contingent beneficiary. Not the trust, it's listed to their name individually. That's going to get paid to them outside of the trust because they were named individually as beneficiaries. Coordinating beneficiaries would mean that life insurance policy's beneficiary designation would be the trust that we created in the will. Mm-hmm. And therefore, the beneficiary designation payout would come directly to the trust instead of to the children individually. That's how important it is to coordinate beneficiaries across the board.
Yeah, absolutely. So your beneficiary designations on these accounts that allow for beneficiary designations really need to coordinate with the rest of the estate plan.
They do. It's all part of the estate plan.
Yeah. Yep. Number 9. How we doing on time there, Mr. Tony?
We're doing pretty good. If we go through these last 2 pretty quick, we just got a couple of minutes left.
Okay, very good. So number 9, failing to consider special needs. Now, I can just say that we've been involved with Chip on numerous accounts or clients that we've had that have had special needs situation. But tell us a little bit about special needs.
Special needs would be a child who, because of some incapacity, is getting Social Security benefits, some sort of government benefit. And it's need-based. So if they receive too much money, it's going to kick them off of their benefits. Mm. So what we do in estate planning is we can create a special needs trust for them. And it's very specialized. I could give a whole talk show just on this. So I'll be very brief and just tell you that we would create a special needs trust so that the federal government can't look to those assets as assets of the child. The assets can be used as an offset or as an extra portion for their care and for whatever else they need. But the government can't count it as an asset, so it won't jeopardize their benefits. It's very important. I, as an estate planning attorney, will always ask about children. Always ask them, do you have any special needs children? Because if you don't plan accordingly, you could really disrupt their life going forward.
Mm-hmm. It could mess up the benefits that they're receiving.
Correct. And it goes back to coordinating beneficiaries, because if you want to name them as the beneficiary of any sort of retirement account, again, you want to drive it to that special needs trust.
Correct. Last one, ignoring trust, overlooking the use of trust to protect assets and avoid probate. So this is back to the big bad probate discussion.
There's reasons for trust. Of course, if you're minor children, you always want to have a trust. A lot of people still will ask you about living trusts and the need for living trust to avoid probate. As we've discussed before, not really that necessary in Louisiana. I don't find probate to be that difficult.
Right.
A lot of times people will create trust and they spend half the time wanting to get out of the trust.
Yeah.
But are there needs for trust? Absolutely. Multiple properties, have properties in different states. You just
special needs.
Special needs. There's all sorts of reasons for trust. And again, that could be a whole topic of its own. But just, don't come in thinking to a meeting with an attorney, I'm getting in living trust because that's what I've always heard I need. Make sure you understand the ramifications and exactly what it is.
Right. You might create more complication than need be, really.
Correct. And then, lastly would be irrevocable trust. Again, needed some, if there are state taxes, there may be reasons to do it with a $13 million exemption. There may not be a reason to do an irrevocable trust. Again, meeting with an attorney would be able to walk you through all the pros and cons of trust.
Right. Absolutely. Well, very good. So top 10 estate planning mistakes and how to avoid them. We really, feel strongly and passionately about just having a very orderly and organized estate plan. It's not expensive to have. I mean, Chip, for somebody to come in just a straight, will, living will, power of attorney, just the estate planning documents, primarily needed. What's some cost range for that?
I would say the cost range is somewhere between $1,000 to $1,500, depending upon the level of trust. That if they're doing a specialty deeds trust, it'd be a little bit on the higher end because of the specialty of it. But it's somewhere between $1,000, $1,500.
Yeah, so we're not talking about the thousands and thousands and thousands of dollars to really get our estate in order.
No.
Right. Well, you know what? We're almost out of time, guys. We need to wrap it up.
Yeah, well, very good. Well, folks, we really appreciate you tuning in. We hope you enjoyed the show. If you have any questions or concerns, you can always reach us at crescentcityretirement.com or give us a call at 504-828-2171. That's 504-828-2171, and we really appreciate Chip's time today.
Thanks for having me.
Yeah, thank you, Chip. And that does it for today's episode. We'll talk to you next week.
Thank you for listening to Wealth Builders. Don't pay too much for taxes or retire without a sound income plan. For more information, please contact Anthony Kangemi at Crescent City Retirement Group by calling 504-828-2171 or visiting them online at crescentcityretirement.com.
Fee-based financial planning and investment advisory services are offered by Crescent City Retirement Group, LLC, a registered investment advisor in the state of Louisiana. Insurance products and services are offered through Crescent City Insurance Group, LLC. Crescent City Retirement Group, LLC, and Crescent City Insurance Group, LLC are affiliated companies. All matters discussed during this show are for informational purposes only. Each individual situation may vary, and the opinions expressed here may not apply to everyone. Materials presented are believed to be from reliable sources, and no representations can be made as to its accuracy. All ideas and information should be discussed in detail with one of our qualified representatives prior to implementation. We are not affiliated with or endorsed by the Social Security Administration, the Federal Medicare Program, or any other government agency. Calling this number will direct you to a licensed sales agent.